This is Barry Zalma speaking for Claim School Incorporated about the August 15, 2022 issue of Zalma's Insurance Fraud Letter, Volume 26, Issue 16. In this issue, there are lengthy articles taking up approximately 20 pages of text, starting with an article about the danger of litigation financing and how the United Kingdom is dealing with this type of financing. The story deals with Timothy Scholes, 61, a corrupt, non-litigating lawyer called a solicitor in the UK, who lived a life of luxury on an estate in Cumbria as he fleeced investors out of more than £25 million and is now facing jail. Southwark Crown Court heard how Scholes ran a scheme financing loans to law firms in no-win, no-fee cases, what we call contingency fee cases here in the United States, between December 2008 and October 2012. The jury reached a verdict on the case only after 28 hours of deliberation. Scholes will be sentenced at Southwark Crown Court on Thursday, 18th August, and remains in custody until that date. Judge Beddoe was quoted as saying to Scholes, quote, "I simply don't trust you to turn up. I refuse bail, and you will remain in custody until Thursday." The article goes on explaining the reasoning for the decision. Then there's an article about the need to comply with California claims regulations, which require that insurers licensed or operating in California must file their SIU or Special Investigative Unit annual reports by September 28. Failing to file can cause the insurer to be fined considerable amounts or lose their right to do business in the state. Insurers are licensed to operate in California must also ascertain that their entire claim staff has read, understood, or has been trained about the California Fair Claim Settlement Practices regulations by September 1 of each year, and be ready to swear under oath that the regulation has been complied with by the insurer. Compliance can be assisted by purchasing a copy of my book, California Fair Claim Settlement Practices Regulations 2022, and California SIU Investigations, all of which are available from Amazon.com. The newsletter also contains an article called "Insurance Fraud is Growing Logarithmically," and how the use of soft fraud has increased the costs of doing business of insurance in the United States. Insurance fraud, soft fraud, of course, is a misnomer. Fraud is fraud, a misrepresentation or concealment of material fact made to deceive an insurer that actually deceives the insurer to its detriment. Those who use the term soft fraud attribute it to fraud of opportunity, like adding to a legitimate claim to recover deductibles or premiums paid over the years, while hard fraud is a fraud that is premeditated. In the U.S., fraud attempts have risen about 22% in the last year, an amount much lower than the global average, but still on the plus side. Then there's an article about how another Florida insurer has gone bust. Weston Property and Casualty Insurance Company is insolvent and is being placed into receivership. This is the 5th Florida property insurer this year to be dissolved. The Florida Office of Insurance Regulation on August 2, 2022 filed notice with the Department of Financial Services that the 10-year-old Weston with about 22,000 policies in the state is insolvent or about to become insolvent. And there's another lengthy article about health insurance fraud convictions, where, for example, Informed Diagnostics agreed to pay $16 million to resolve the False Claims Act allegation of medically unnecessary tests. There's a listing of other insurance fraud convictions, such as the conviction of Wellman Dynamics, a Creston company that manufactures large metal castings used by military contractors, including Bell Helicopter, Sikorsky Aircraft, and Boeing Company, and they will pay $500,000 in restitution to the U.S. government to settle allegations that the Southwest Iowa company that makes metal castings for helicopters and other equipment failed to test the castings and falsely certified test results over 7 years. And there's a lengthy article called The Fifth Amendment and the Examination Under Oath, which was adapted from my book on the examination under oath and my books on insurance fraud. And it starts with a reminder that Fremont Indemnity Company versus Superior Court, a 1982 decision of the California Court of Appeal that concluded that the privilege against self-incrimination as to factual issues, especially with application to arson exclusion, waived by filing suit over rights under a fire insurance policy. The reasoning of cases such as these is that the gravamen of the lawsuit is so inconsistent with the continued assertion of a privilege as to compel the conclusion that the privilege has and had in fact been waived. While the Fifth Amendment privilege of a criminal defendant is absolute, a party or witness in a civil procedure may be required either to waive the privilege or accept the civil consequences of silence if he or she does not or does exercise it. There is a broad range of civil sanctions that may be imposed on a litigant who asserts his or her Fifth Amendment right, but the severity of such sanctions generally depends on whether the party invoking the privilege is the plaintiff or the defendant. Where the plaintiff in a civil action claims the privilege and refuses to testify, the court may dismiss the action on the basis that one may not invoke the judicial process seeking affirmative relief and at the same time use the privileges granted by the process to avoid development of proof having a bearing upon his rights to such relief. So it is best in a bad faith type situation to not file suit for declaratory relief, but compel the plaintiff to sue the insurer and then assert his Fifth Amendment privilege. And if he does, he must dismiss his lawsuit and the case will be won. Then there's an article on healthcare fraud and fraud committed by medical providers, listing the various types of fraud and how to deal with them. There are reports of convictions from the Coalition Against Insurance Fraud. There is an article on fraud convictions in detail and reports of convictions from both health insurance fraud and other than health insurance fraud. You can access the full 20-page PDF format newsletter by clicking on the links that are part and parcel of this video and by reviewing the blog posting, or simply go to Zalma.com and click on the link for the insurance fraud letter. Thank you for your attention, and please subscribe so that you never miss an issue.